All right, hello everyone and welcome. I'm Leonard French, your favorite copyright attorney, and today we are reviewing a new decision from the Seventh Circuit Court of Appeals. If you're not familiar with our channel, I'm an actual copyright attorney practicing in the United States and defending people from piracy cases, and I like to review various copyright-related decisions and other ancillary legal decisions, but primarily copyright. And today we have a sort of serial episodic presentation for you. This is the, I think, third or maybe fourth video I've done about this company. This company is called Design Basics, and they like to enforce copyrights on home floor plans. You can find their website at designbasics.com. And in theory, there's really nothing wrong with making a house floor plan or an architectural design or something and enforcing the copyright. The problem is that the copyright for an architectural design or a floor plan, you have to meet some basic minimum creativity requirements before you actually gain copyright protection. Simply drawing boxes on a sheet of paper or on a floor plan does not give you copyright protection. There has to be something more. And to reinforce that, let's look at the court's opinion. They'll describe the background and what's been going on between Design Basics and Kirstein's Home and Designs. This is Judge Scooter from the Seventh Circuit Court of Appeals, and they write, "Copyright law protects individual expression while encouraging creativity and maintaining the public interest in spreading ideas. In recent years, however, a cottage industry of opportunistic copyright holders, earning the derisive moniker intellectual property trolls, has emerged, in which a troll enforces copyrights not to protect expression, but to extract payments through litigation. Design Basics fits that bill. The firm, which holds copyrights in several thousand single-family home floor plans, has brought over 100 infringement suits against home builders in recent years, but many defendants, the targets of the settlement extraction scheme, are starting to push back. This case is a good example. We have affirmed dismissal of Design Basics lawsuits twice in recent years. See Design Basics versus Signature Construction. We recently did a video on that, so when this becomes a video on demand, I'll put a bubble at this point. And Design Basics versus Lexington Homes, which was discussed in the Signature Construction case. We do so again today. In dismissing Design Basics' copyright infringement suit against the Kirstein's family home building business, the district court recognized that the firm has a thin copyright in its floor plans because they consist largely of standard features found in homes across America. We agree and affirm the dismissal. And now the court goes into the background. The Kirstein's family runs a collection of companies that build single-family homes out of Jasper, Indiana. Plan Pros, Inc. and Prime Designs, Inc. are home design companies that license their plans through Design Basics, which acts as a plan broker of sorts by serving as an intermediary between home builders and design firms. Design Basics started out as a small residential design firm in Omaha, Nebraska. It markets the thousands of plans it holds copyright to through trade publications, promotional materials placed in home improvement stores and national builder associations. In recent years and under new ownership, Design Basics has become a serial litigant. Indeed, litigation proceeds have become a principal source of revenue for the firm. The firm also draws income from a licensing scheme for its designs, with fees ranging from $700 to $6,000 per use. In two of our prior cases, we have underscored that Design Basics, while holding itself out as a home designer, is a copyright troll. The firm seeks to extract rents from market participants who must choose between the cost of settlement and the costs and risk of litigation. The model is simple. Design Basics holds copyrights to thousands of home floor plans, and its employees receive incentives to stalk the internet in hopes of finding a target for an infringement suit. Kirstein's was one such target. In 2013, a Design Basics employee, ostensibly doing market research to develop more business in Indiana, came across Kirstein's website and saw a few design plans that he believed infringed the firm's copyrighted works. Design Basics and the two design companies then brought this suit in 2016, alleging that 10 Kirstein's designs infringed 7 copyrighted plans. And this is when we talk about how copyright law is broken, this is one of the examples people bring up, is how a copyright plaintiff can pressure even an innocent defendant to pay a settlement or a license fee just to avoid having to hire an attorney and go to court. And when I talk to my clients, I do the same thing. I have to explain that some of these plaintiffs are pressuring even innocent defendants to settle their case, because if you pay a few $1,000s to a copyright plaintiff, that's probably still less money than you're going to risk in court. If you lose in court, copyright damages are $750 per title for properly registered copyrighted works at a minimum, and it can go up from there. So it's a risk and it's a cost. It's kind of a business cost of doing business to just pay a nuisance settlement and get some of these plaintiffs to go away. Not every copyright plaintiff is insincere or copyright trolling, but there is this loophole or this gap in law that allows them to do that. Design Basics and the two design companies then brought this suit in 2016, alleging that 10 Kirstein's design infringed 7 copyrighted plans. In time, Kirstein's moved for summary judgment. The district court granted that motion and awarded costs and fees, concluding that Design Basics could not show substantial similarity between its copyrighted works and Kirstein's alleged infringing plans under the standards we announced in the previous case of Design Basics versus Lexington Homes. The competing floor plans, the district court explained, had some similar features, but that was not enough under the Lexington Homes standard to establish substantial similarity between the architectural works. The copyright standard is substantial similarity or worse. There's something called striking similarity, and there's something where there's actual verbatim copying. So substantial similarity is sort of the least amount of similarity you can get away with and still be infringing a copyright. So a plaintiff can sue for substantial similarity, striking similarity, or actual verbatim copying. The superficial similarities between the designs were not unique to the home plans before the court. Indeed, the similarities could be found, the district court emphasized, in many homes: kitchens near dining rooms, master bedrooms with large bathrooms, and on and on. So Design Basics could not succeed on its copyright infringement claim. In a later order, the district court then awarded Kirstein's $518,000 in costs and fees. Design Basics now appeals. Now, before we go on with the court's analysis, I brought up from a previous case an analysis of how simple these are. This is from the Signature Homes case. These are the floor plans we're talking about. Not at issue in the Kirstein's case, but this is the kind of thing. This is an example of how simple these floor plans are. So here's an external drawing of a design that basically shows a 2-story, what would be an A-frame house. I'm not an architect, with a enclosed porch area and an attached garage, a single car or 1.5 car attached garage with a driveway and a sidewalk. And then here's the internal floor plan for that. You've just got a 2-car garage attached to a dining room, a covered porch, a study area, kind of an angular walkway, a half bath, a family room, a breakfast area, a kitchen, and a pantry. And that's all pretty standard for floor plans. So if somebody copied this exact floor plan, I'm not even sure if an exact copy of the floor plan is copyright infringement, because it's a simple floor plan that has been done hundreds of thousands, if not millions of times before in and really around the world in building homes. I don't necessarily mean that this exact design has been used 100,000 or 1,000,000 times or whatever, but it's been used a lot. It's been used a lot, enough that it's a standard in the industry to have these kinds of floor plans for single-family homes. This is then an analysis that an expert witness did. I think it was Design Basics expert witness, trying to show how, again, this is the signature floor plans case, not the Kirstein's that we're talking about here, but this is an example of how a master bedroom on the top is similar to a master bedroom on the bottom, but you can see they're not exact. Even though there is a closet in the same place and a master bath in the same place and bedrooms in the same place, they're still slightly different. And so the question was whether these are substantially similar, and the court's going to go into why, even though they are similar, why we don't protect that level of similarity. There has to be something more. Our two recent decisions, Lexington Homes and Signature Construction, affirming judgments against Design Basics, more fully describe the copyright law framework and how it relates to the firm's questionable business model. Lexington Homes guided the district court's conclusions, and we more recently decided Signature Construction, which again foreclosed much of Design Basics' claims. Those decisions all but resolve this appeal. So the court's saying that if you want to go into a super detailed level of analysis, go look at Lexington Homes and Signature Construction, which we can certainly look at. I've already done Signature Construction, and Lexington Homes is maybe something I'll cover again. Copyright protection exists, the Constitution makes clear, to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. That is the U.S. Constitution, Article 1, Section 8, Clause 8, and the court also wants to emphasize that Google has, the Google case, the Google v. Oracle case, has also recently affirmed that sort of the importance of that clause. And of course, my PDF reader is now going to screw up. The Copyright Act codifies that principle. Among the mediums protected by copyright are architectural works. See 17 U.S.C. 102A. Of course, I'm going to mess up my highlighting. There we go. And let's change the color. Encompassed in that definition are the overall form as well as the arrangement and composition of spaces and elements in the design, but it does not include individual standard features. So then the court's going to go into what is a standard feature. To establish copyright infringement, Design Basics must prove ownership of a valid copyright and that Kirstein's copied elements, constituent elements of the work that are original. So it's not just is something substantially similar, it's did you copy the protected elements? Is there substantial similarity in the protected elements? If I just draw a square, that's not protected. I would have to do more than just draw a square. So if you copy my square, well, have you copied anything that was original to me that met the minimum creativity for copyright? Probably not. And so you've not committed copyright infringement. This appeal concerns only the second element. Embedded within that element are two distinct questions: whether the defendant copied the protected work and whether the copying constituted an improper appropriation. The first question asks whether the defendant actually duplicated the work. The second inquiry, which is dispositive or disposes of the case for our purposes, concerns the degree of unlawful appropriation. We separate the elements of a work, the protected elements from the unprotected elements, and then assess whether the protected elements were improperly appropriated. Improper appropriation, or wrongful copying as the lingo goes, requires substantial similarities between the defendant's work and the protected elements in the plaintiff's copyrighted work. We employ the ordinary observer test, so that's what it's called in the Seventh Circuit, to assess substantial similarity, assessing whether the accused work is so similar to the plaintiff's work that an ordinary reasonable person would conclude that the defendant unlawfully appropriated the plaintiff's protectable expression by taking material of substance and value. So that's really complicated. If you get to be that ordinary reasonable person, like say if you're a jury member in a jury for deciding a case during a trial, which this was not. This did not go to trial. This went to summary judgment, no trial. The jury would be asked to figure out if anything protectable was copied. So first you have to figure out what's protectable, and then you have to figure out whether that protected stuff was copied. In fields defined by common features and dictated by functional concerns, copyright protection is very weak. So common features and functional concerns, copyright is very weak. The suburban single-family home and the design industry surrounding it is one such field where copyright protection is thin, such that proving unlawful appropriation takes more than a substantial similarity between the plaintiff's work and the defendant work. As we explained in Signature Construction, only a virtually identical plan infringes the plaintiff's copyrighted plan. So remember the example I gave before, you would have to copy a floor plan exactly. Yeah, you'd pretty much have to copy the exact floor plan that the plaintiff had created. We drew this conclusion in part from two separate copyright doctrines, scène faire and merger. French for scenes of action, which is that's a new definition or new translation I've seen. If we go over here to the scène faire Wikipedia article, it usually means scenes to be made or scenes that must be done. And they are scenes which are obligatory or standard for a genre. So, a space movie will have spaceships and stars and planets and things. So just because you have spaceships and so does your opponent have spaceships, that doesn't mean that you copied each other. You're allowed to have spaceships in your space movie. In similar vein, you're allowed to have bedrooms in a floor plan. You're allowed to have kitchens in a floor plan. Those can't be copyrighted. The something more is the design of your kitchen, the specifically protectable architectural elements that the court's going to go into. Scène faire refers to the standard elements of a genre which get no copyright protection. And for its part, the doctrine of merger helps separate out the weaker protection from the stronger protection. Do they go into the doctrine of merger? Yes. Copyright protects expression, whereas patent protects ideas, concepts, and functions. When something can be expressed only in a limited number of ways, the expression merges into the idea and cannot receive copyright protection. What the court is saying is that copyright does not protect ideas. And so when there's only a limited number of ways to express something, well, those expressions of the idea are the same thing as the idea itself, and ideas don't get protection. With these principles of copyright law in place, we can make quick work of design basics claims. Just as we did in Lexington Homes and Signature Construction, we conclude again today that design basics did not prove an infringement claim. Design basics failed to show that its copyrighted designs and the allegedly infringing Kirstein's designs are virtually identical. Design basics cannot make a case of copyright infringement because the many similarities it points to are standard features not strongly protected by copyright. The design basics plans at issue are just that, basic, common, and standard designs entitled to very little copyright protection. Consider just one of the allegedly infringing designs. The top floor plan is the Kirstein's 704 plan, which design basics alleges infringes on its Duncan plan, the bottom of the two. Great, so here the court's going to go into an example. Here is the Kirstein's plan on top and the design basics plan on the bottom. I'll zoom out a little bit so you can see. So this is a difficult one for me to see how these infringe. You've basically got two floors of a single family home. The first floor, as we say in the US, the ground floor, has a kitchen, nook, and dining room, and is basically flipped horizontally from design basics plan. And yeah, sure, they look similar, but they're also different. So unless there is an identical copying or actual provable verbatim copying, no dice. The design basics second floor is proportionally different, has a different number of bathrooms, it looks like, has differently proportioned bedrooms. The walk-in closet is a different size, different number of sinks in the master bathroom, etc. So it's not identical, and it's certainly not identical and copied. Kirstein's 704 plan on the top, to be sure, bears many similarities with Design Basics' Duncan plan on the bottom, but those similarities are bound up in standard features, and functions found in many homes. It is of no moment that both have a garage or a laundry room off of the garage, nor is it concerning that both designs feature 3 standard bedrooms on the second floor. No one would expect a house to have its kitchen on the second floor rather than the first floor, and that goes to the merger doctrine and the Senefaire doctrine. It is standard to have the entrance to a house go through the laundry room, because the laundry room is often a room that's been reinforced against exactly those things. Dirt coming in from the outside. It usually has a tile floor or a linoleum floor, usually not a carpet. You certainly could, nothing's stopping you, but a standard common expression of the idea of home design is to have the laundry room right there. If you come inside and you're dirty or wet, you can just take your clothes off and throw them in the washing machine or throw them in the sink or something and de-dirt yourself before you enter the cleaner parts of the home. That's really standard. You might not have that same commonality of laundry room should it be on the second or third floor. Definitely, I've seen homes that have that. It doesn't mean that it violates the Senefaire or merger doctrines. It's just fairly standard to have the laundry room off of the garage. So just because you have a laundry room off the garage doesn't mean that nobody else can ever put a laundry room off the garage. That's not a protectable element of copyright. Count the differences too. The layouts are distinct. For example, the Duncan garage is on the right side of the house, the Kirsten's garage is on the left. And the district court pointed out most of the room dimensions are different. The Duncan model includes a fireplace in the living room and a desk in the third upstairs bedroom. Neither feature can be found in the Kirsten's plan. The Kirsten's plan has some distinctive features of its own: an outside entry side door to the garage, a back patio, and a second closet in the master bedroom, to name a few. We could spill more ink explaining the standard similarities and the many differences across all of the allegedly infringing designs, but doing so is unnecessary. Just this one representative sample comparison suffices to show why the district court was right to reject Design Basics' infringement claim at summary judgment. Pick any ordinary neighborhood in the Chicagoland area, the same observation follows. Similarities abound between the selected homes and the plans that Design Basics seeks exclusive claim to. The industry standard suburban single-family home is rife with common features for many reasons, but copyright infringement is not among them. Developers cater to vast numbers of potential home buyers wanting homes with lasting market value, so they build houses broadly attractive to all comers. And as we have observed, form follows function so closely in the market for affordable single-family homes. There are only so many ways to arrange a few bedrooms, a kitchen, some common areas, and an attached garage. Not every nook and cranny of an architectural floor plan enjoys copyright protection. Design Basics offers over 2,800 floor plans. We would be hard-pressed to find a standard American home bearing no similarities to at least one of these floor plans. In cases involving fields in which copyright protection is thin, only extreme close copying is actionable as unlawful infringement. Design Basics has not satisfied that exacting standard. A design that shares similar standard features when taken together to form a whole may look like potential infringement at first blush. Copyright law rewards original expression and innovation. It does not protect rent seekers looking to score a quick settlement rather than compete. Having successfully fought off a dubious lawsuit, Kirsten's Homes was entitled to an award of attorney's fees and costs under the Copyright Act, 17 U.S.C. Section 505. The district court awarded $518,457.90, and we affirm that award. In copyright infringement suits, there is a strong presumption that prevailing defendants may recover costs. Still, that presumption, and in the district court's discretion, must be moored in sound legal principles that look to the very large objectives of the relevant act. The Supreme Court instructs that district courts look to several factors when exercising their broad discretion to shift fees in copyright cases, including frivolousness, motivation, objective unreasonableness, and the need to advance considerations of compensation and deterrence. The district court exercised sound discretion in awarding Kirstein's costs and fees, carefully considering the Fogarty factors and concluding that awarding fees would discourage Design Basics from manipulating the copyright laws to extract quick settlements. The district court's evaluation of Kirstein's cost request was just and thorough. We see no abuse of discretion for these reasons. We affirm in the Seventh Circuit Court of Appeals in Design Basics versus Kirstein's Home and Designs. And that should be, I hope, the end of Design Basics copyright trolling. It sounds to me like someone got it in their head, the plaintiff got it in their head that they could make a quick buck by suing everybody who presumably copied. And this is when we see in YouTube comments that people say, oh, well, you copied this little thing, you must be guilty of copyright infringement. When NBC, I think it was NBC and Paramount, made the Star Trek Tardigrades episodes, and Nasruddin sued because he also wanted to make a Tardigrades in space story, those things weren't similar enough. Just because you want to put a tardigrade in space as part of your story doesn't mean no one else can ever put a tardigrade in space. It's how you put the tardigrade in space. It's all of the choices that you make. Did you make your tardigrade human-like, humanoid? Did it have human personalities? Was it animal-like? Did it have a name? What was that name? What color was it? What did it do? What was the plot? What was the character arc? What was the background scenes? Not any one of those things is copyright protected. It's the combination of all of those things. So just suing because one party put a tardigrade in space and then another party put a tardigrade in space wasn't enough to gain copyright protection over the other. Everybody can go make a space movie with spaceships and stars in the background and places to visit and planets and things that happen in space. It's when you start to copy the original elements, the things that are new, that aren't common to the genre. So same thing with the floor plans. Just having a master bedroom and a bathroom off the master bedroom and a staircase to the first floor doesn't mean nobody else can make a master bedroom, a master bathroom, and a staircase to the first floor without paying you a license fee. Everybody can make a single family home. What they can't do is copy your exact design. So I think that's really interesting. They shut down the copyright troll. The defendants get $500,000 in fees. It's a little scary that one of these court cases costs $500,000 to get to this point, but that's unfortunately pretty typical. And I think we have an access to justice discussion to have there. And that's what I have for you today. So thanks for joining me. I'm Leonard French, your favorite copyright attorney, and thank you very much to our supporters on patreon.com/ljfrench and sponsors.com/law. Special thanks in the month of June to our $50 plus supporters, Joe Tyson, John Steele, Gavin Barnard, Eevi, Spirit Bear, Benjamin Hitov, Ugly Grill, Rudolph Bescherer Jr., Torpedan, Brandyn, Abel, ShadowTycho, Earthbound Star, RDHDragon, and PureMagma. And all the $5 plus supporters are scrolling on the panel behind me. I love you all. Have a great week, and I'll see you in the videos that drop. Bye. Oh, and thanks PureMagma for the $20 super chat. Really appreciate that. Love you. Bye.